Good morning, colleagues. I guess everybody grabbed coffee, so we can start now. So it is my pleasure to welcome you all on behalf of the permanent missions of Latvia, Mexico, and Romania to this discussion on the International Law Commission and compensation in the law of state responsibility. I believe I do not need to persuade this expert audience of the key role that the ILC plays in codification and progressive development of international law. And the choice of today's topic and framing of the panel reflects the shared view of the organizers on the importance of discussing such universal and legal challenges through mechanisms of the United Nations, including the ILC. It remains to me to introduce the chair of this panel, Professor Martin Paperinskis. He's Professor of Public International Law at University College London, and he's a member of the International Law Commission, to which he was elected upon the joint nomination of Latvia, Estonia, and Lithuania. And this year, he's also the chairperson of its drafting committee. So, Professor Paperinskis, you have the floor.
Thank you very much, Madam Ambassador, and let me begin by thanking the missions of Mexico, Latvia, and Romania for organizing the event, which I'm really delighted to chair and moderate. I'm reminded of a very earnest student who said to me once that he loved the standard of review in investment arbitration, but that he didn't do quantum. Well, in my experience, clients are rather keen on quantum. Some of you may recognize the inimitable turn of phrase of the much-missed great international lawyer, Professor and Judge James Crawford, and this comes from his Hudson Medal lecture that he delivered in 2012, and that was published in ASOL Proceedings. And I think the broader point that we can take away from Professor Crawford's insight is the point about the importance of compensation, and naturally for him in the framework of state responsibility in international law, and particularly in the practice of international law. I want to make 4 points and a coda, and then I will pass the floor on to the wonderful speakers. The first point is that the purpose of this panel is to test the hypothesis, and the hypothesis is that the topic of compensation under the law of state responsibility is an important one in the practice of states, and this is one that is framed by the existing work of the International Law Commission, but may benefit of greater granularity and identification of the better examples of application. The second point is that the International Law Commission's existing work provides us with a sophisticated analytical apparatus for addressing points at issue, from the Articles on Responsibility of States for International Wrongful Acts in 2001. We know important aspects of international law, the distinction between primary rules and secondary rules, and compensation as one of the legal consequences and forms of reparation that flow from the breach of international law. The third point relates to importance. Importance in decisions and practice of international courts and tribunals in interstate setting, as well as before bodies considering claims brought by entities other than states in fields of human rights and investment law. And if you look at this wonderful book, the second edition of Materials on Responsibility of States, ably compiled by the wonderful people at the UN Codification Division, there's a great deal of practice that engages with these matters. It is also something that is engaged with in and through international institutions. We are very familiar with the damages register that was established after the ICJ advisory opinion on the Israeli wall, and there's another discussion in one of the parallel conference rooms on a more recent pertinent example in this setting. And in all three most recent cases introduced before the International Court of Justice this year, compensation is a specifically requested remedy. And I think you as practitioners with international law will appreciate that many times examples before international courts are like concentric circles spreading on a lake. if there are a number of cases before courts, there are many more cases that states are thinking about and reflecting upon. So this does seem to be a pertinent practical issue. The fourth point is that there appears to be scope for engagement, for provision of greater granularity, and identification of the better examples of application in diverse fields of international law. So this is a hypothesis that I would be interested to see tested today. And the coda, which I note without returning to, that a possible topic on compensation under law of state responsibility is under consideration by the Working Group on Long-Term Program of Work. So this event is an opportunity to invite states to reflect upon the possible role of the ILC in these matters. It brings me great pleasure now to introduce the eminent expert panelists. Christina Behari, who will speak first, is a partner at Foley Hoag in Washington, and her primary areas of practice are international arbitration, particularly investor state and public international law, and previously she was counsel in the Department of Foreign Affairs and International Trade in the Canadian government. The other four speakers will be well known to all of you as colleagues. Natalie Jimenez Alegria is the legal advisor of the Permanent Mission of Mexico to the United Nations. Mahavini Kondere is the legal advisor of the Permanent Mission of Uganda to the United Nations. Alice Lungu is the legal advisor of the Permanent Mission of Romania to the United Nations. And Azela Rumpak is the legal advisor of the Permanent Mission of Philippines to the United Nations. So a great spread of regional and professional diversity on these matters. I think our aim is to provide glimpses and possible insights from a variety of regional and professional perspectives, and, timetable permitting, collect a few questions in the end of immediate reactions from states. Without further ado, I am passing the floor to Christina.
Thank you, Martin. Do I need to switch this on? There we go.
I'd like to start off by thanking the missions of Latvia, Mexico, and Romania for the kind invitation to speak to you all this morning. As Martin's mentioned, I am a former counsel in the Canadian government, and I currently work exclusively representing sovereigns. So I approach these issues with that particular lens, both as a functionary and as counsel to states. So there are two aspects in which compensation obviously is relevant to state interests. One is a defensive perspective. So this typically arises in the context of investor-state arbitration, which I will refer in shorthand to as ISDS. So these are claims brought by foreign investors against states under bilateral investment treaties, FTAs, and domestic investment laws. In that context, damages is truly a third line of defense, and it's something that I particularly focus on. It's often given as an afterthought, but it can really prove to be quite a robust line of defense as well. States may also face claims of compensation through human rights contexts, so that are brought before international courts like the Inter-American Court of Human Rights or the European Court of Human Rights. Conversely, states may also bring claims for compensation in the context of ISDS. This usually manifests itself through counterclaims. Those of you who are familiar with ISDS will know that counterclaims in practice typically don't fare with much success, particularly if they are brought under the dispute resolution provisions of treaties. There is also potential for claims being brought in commercial arbitration. So here we see it mostly through state-owned entities that bring claims against a commercial actor. And thirdly, and this is perhaps much more rare, we see a handful of cases where compensation is sought by one state against another state. And I have some practice with that as well. But clearly, the bulk of the practice is coming from ISDS, where compensation is really central to the claims that are being brought. Despite this, investment tribunals are still guided by international sources on compensation. So most centrally the ILC articles, as well as seminal cases like the Chorzo factory case. So as I mentioned, there's only been really a handful of cases, interstate cases, that have resulted in an award of compensation, particularly in modern times. In most of these cases, or in most cases, rather, the traditional remedy has been declaration, satisfaction, restitution, and of course, guarantees against non-repetition. In cases where compensation has been sought and granted, it has been in relation to property damage, environmental damages, and with respect to moral damages or non-material damages. So, as Martin alluded to, I think that compensation is really receiving greater attention in recent years, and it's important that international law reflects this reality. I'm going to make three brief observations regarding certain features of interstate cases that I think has a tendency to hinder, in a sense, the award of compensation. I may only get to two in the interest of time, but I think the first two are the most important. The first is with respect to the limited experience of international adjudicative bodies in assessing compensation. Valuation methods are not, at least expressly, applied in awards. Instead, courts often end up resorting to considerations of equity. So we see this in, for example, the DRC Uganda case, where reference was made with respect to global sums in the case of mass atrocities, but I won't go further than that because another panelist will be speaking about that case. And similarly, we have seen claims for moral damages accepted in the Diallo case, which will also be covered in greater depth. But this really contrasts with the investment world, where certain practices have truly developed. For example, with respect to non-operating investments, tribunals typically resort to the sunk costs method of valuation. It's only when there is a track record of profitability that tribunals will be more receptive to income-based approaches such as the discounted cash flow method. And I'm seeing with greater frequency more sophisticated methodologies being used, such as real options, scenario analysis, Monte Carlo. So it can get very technical in valuation, in terms of valuation. Relatedly, I think that this limited experience with awarding compensation may also be a reflection of issues relating to evidence collection and evaluation. That brings me to my second observation. So collection of evidence has been a major hindrance in some cases. We see that again with the DRC Uganda case, where 17 years had lapsed between the award on the merits and the award on compensation. That led to the court rejecting a good amount of the damages being claimed in that case. So there may be a role here, I think, for potentially grassroots organizations or civil society, or potentially with the UN bodies to help states with collection of evidence. Martin's alluded to the recent example also of the International Register of Damages. That was also something that was considered and approved by the Council of Europe in May earlier this year. I won't get into the rules of the statute of the International Court of Justice, but there are hallmarks for traditional litigation that are embodied in those rules. with respect to expert evidence, the appointment of experts, the questioning of experts and witnesses. So it may be really a question of states utilizing these mechanisms. And I'll just very briefly touch on the third, which has to do with the scope of compensable damages. There are certain guiding principles, like I alluded to earlier, that are well known and applied, such as the full reparation principle under the Chorzów factory case, Article 36 of the ILC articles, which provides that compensation must be paid in relation to any financially accessible damages. But we're seeing there are new and innovative claims that are on the horizon. In the ISDS context, I'm facing claims now for loss of opportunity. So not the value of the asset itself, but the value of the potential of that asset, which is at odds, one would think, with the traditional rules of compensation. In the DRC Uganda case, claims were made with respect to macroeconomic harms. I think looking forward to the future, we may see more in the realm of environmental harms, damages for environmental harms. We've seen that with the Costa Rica, Nicaragua case, which will also be discussed later on today. I think where that will potentially have a prominent role is in respect to climate change. We know that there are several advisory opinions that are currently pending, so stay tuned to see whether that leads to claims of compensation. And of course, with recent world events, international adjudicators may be increasingly seeing claims with respect to mass atrocities, genocide, and armed conflict. So I'll conclude here with just a couple of thoughts. So given the growing relevance of compensation in international disputes, I do think the time is ripe for us to be collectively reflecting on the current legal framework on compensation. Whatever reform that is undertaken, states will need to consider the various contexts in which compensation claims may be brought. I've already mentioned ISDS several times. I think that's a really interesting example because states must now not only be concerned about the claims that will be brought against the state itself, but also about claims that may be brought by investors from that state against other states. And so some careful balancing will be required. That's because, of course, FDI is not just coming from capital exporting Western countries. It's from countries with varying levels of development. There are certain initiatives as a result in the investor state sphere at the moment where compensation is being considered. One is within states themselves and undertaking reviews of their model BITs and making provisions. For example, I think a really interesting one comes out of some of the African model BITs, which provide for an equitable balancing of public interests and the interests of those affected. Similarly, the UNCTRAL Secretariat has come up with 9 proposals on compensation that were recently discussed as late as last week for states to consider implementing through their own treaties or as guidance. So clearly, compensation is on the minds of states at the moment. To be determined what will happen within the ILC, but I think the time surely is ripe to be thinking about these issues. Thank you, Martins.
Thank you, Christine. I think it's a very nice introduction of the overall theme of the panel, of the variety of institutional and strategic contexts in which the general secondary rules of state responsibility may fall to be applied, and the variety of considerations that have to be on the minds of international lawyers thinking through it in formulating and developing these rules. Let me now turn to Natalie and give her the floor. Please.
Thank you very much, and good morning, colleagues, and good morning and thank you to the colleagues of Latvia for inviting me this morning. as Cristina clearly had a very interesting and very good introduction, and I think also part of the objectives of this panel is to have an overview of the different regions and the practice and interpretations of the current rules, or whether that we have or not. I have the tremendous responsibility to convey to you the perspective from Latin America and the Caribbean. And to do this, I will try to be very brief, of course, because we know we're limited on time. So I will mainly focus in two developments. One at the international level, and as Cristina in her introduction said, I will focus on the Nicaragua-Costa Rica case, and I'm referring to the decision from February 2018. And also another one at the regional level, and here I'm referring to the advisory opinion by the Inter-American Court on Human Rights, number 23. So briefly, and just for the benefit of everyone, a brief introduction on the on how the court got to the decision on 2018. As you may be aware, this case originates from two previous cases brought by the two different parties, and then later on, the court joined those proceedings. And in 2015, there was a decision on the merits of that case, and basically on that decision, the court found that Costa Rica had sovereignty over the dispute territory that was under review by the court. And by excavating 2 caños, this is on the construction of a road on the San Juan River, and also establishing military presence in the disputed territory, Nicaragua had breached the obligation incumbent by the state. So there was a state responsibility there by a wrongful act, and therefore Nicaragua had the obligation to compensate Costa Rica for material damages. And in this, after this decision in 2015, the court gave the parties 12 months to achieve a solution between them. But that was not the case, and therefore Costa Rica filed again another request to the court asking to set the compensation. And that's where the things got interesting, because the conversation was not anymore on the responsibility and what kind of damage had been done, but also on the compensation. And to have this analysis, there is an interesting analysis by the court, of course, and this is the first time, as you may know as well, that the court recognized that there was, it was also, there was, in the event that there is damage or environmental damage, there is also the responsibility to compensate. And here, Costa Rica claimed 2 different kinds of damages. First, it's environmental damage, as explained, and also cost and expenses. And in this case, there was also each of the parties brought their own analysis on how to calculate this damage. And one was an ecosystem approach by Costa Rica, and the other one was the replacement approach by Nicaragua. But the court actually did not follow any of these in particular. They actually reasoned on the importance to take an overall assessment of the impair of loss and environmental goods. So there's not really a clear methodology that was followed in this case, but there was evaluation on the damages that were caused, and eventually the court arrived to an actual calculation on the damages. And on that analysis, there was also consideration on the regeneration of the wetlands and how those how that impact actually translated into a calculation. And at the end, the court arrived to a conclusion that, of course, Costa Rica had requested a higher amount on damages, and at the end, it was less, of course, less than 5% of the original request. And the conclusion from this case is, of course, that there is a landmark decision, because it's the first time that the International Court of Justice recognizes that there is compensation for environmental damage, but then there's still some also work to do on the part of the methodology that was followed. And then on the regional level, as I was conveying at the beginning, we had a request by Colombia and in 2018 also, right after this first decision, the Inter-American Court of Human Rights rendered its advisory opinion number 23. And this is a very important decision, and perhaps we're going to hear more, and we've been hearing more in all our conversations about the current advisory opinions. And this was also a very progressive interpretation on environmental rights, and in particular, the right to sustainable development in an as an autonomous right. But also in analyzing this autonomous right, the court also analyzed different rights that are comprised within it. Among those, the right to life, the right to housing, among others, and which is interesting also for our conversation today, is the right to an effective remedy. So this is already in consideration, or it was in the consideration by the Inter-American Court of Human Rights. But also the court analyzed obligations. So basically there were 4 that were into that analysis, and one is the obligation of prevention, the precautionary principle, the obligation to cooperate, and procedural obligations. So it was an important decision as well at the regional level. And just to conclude briefly, just three main points. As I said when I finalized the part on the ICJ, well, it's important also, of course, a decision, but there is more work to be done on the part of the methodology. And then on the Inter-American Court of Human Rights, it will be interesting to see what the developments will be as the court analyzes also the new request for an advisory opinion on climate change. And at the end, and just to wrap up from the perspective of state responsibility, it will also be interesting, and as you know, the 6th Committee every 3 years discusses the draft articles on state responsibility, and there is a variety of positions, and Mexico's position is the need to find a way forward. And of course, this is what we've been trying to convey, and perhaps it's also another area where we can continue this discussion. There is always very interesting, heated conversations, but then the result for the past 21 years has been no consensus. But perhaps there is an opportunity there, and as we see the developments in different courts at the international level, at the regional level, there's also, and as Cristina was mentioning, in state and investment disputes, there's also, the topic is ripe to continue the discussion. Thank you very much.
Thank you very much, Natalia, for introducing the Latin American perspective and highlighting contributions in this particular field. I now give the floor to Marvin for giving the African perspective on the topic. Thank you.
Thank you very much. Thank you to the missions of Latvia, Romania, and Mexico for organizing this event. And thank you to Martins for moderating this very important subject. I'll speak on the African perspective, and I will look at it from the point of view of the International Court of Justice, and also from a number of decisions that have been made by commissions established to handle border disputes, and also looking into the African system, which is the African Court on People and People's Rights, which also has made some decisions on issues to do with compensation. So compensation is a very, very important topic for many African states. And I think that this is one that's very interesting, as Natalia said, in the 6th Committee for the last 21 years we've been discussing it, but there's not much consensus achieved. So it would be very interesting to see what the IOC in the long-term program of work will look into while discussing this topic. One of the first cases I would like to look into is the Diallo Amadou case, where there were claims for compensation. And one of the most interesting things that I found in this case was that the court did not shift the burden of proof to DRC in order to demonstrate that the injuries alleged by Mr. Amadou had been caused by its failure to comply with the procedural obligations. I think that one of the most important things that I found very interesting is that, like Cristina said, is that they were giving him, he was awarded, the court awarded damages for non-pecuniary harm and also for personal effects. But this was not premised. They did not have to shift the burden, but rather the evidence was presented based by the applicant and also equitable considerations. It's one of the things that I found very interesting is that they did not have to look into, because the collection of evidence is always a very big challenge, especially for the victims. So you find that the court has to sit and find a way of creating coming up with damages without having to look at all the evidence that's available before the court. And one other case that I would like to look into is also the Ethiopia-Eritrea Claims Commission, where it was said that, which was very interesting for me, is that this was unique and it had considerable presidential value, as such claims have never been really litigated before. And one of the things that I found very interesting is that the Claims Commission took into consideration when making the award was the financial burden that would be imposed on the parties, given the economic condition of the state and its capacity to pay, keeping in mind the ability to meet its basic needs, which is very important in a post-war conflict situation. So this is one of the key issues that always comes up, especially with many African states, is once the award is made, the compensation award is made, implementation and also looking at the economic burden that this places on the state. And sometimes the follow-up mechanisms themselves are also very difficult to, and this is difficult to move on to, because this is mainly due to lack of, I think, more resources and also having people to follow up the compensation claims. And I'll also look into the armed activities case, which was already mentioned by Christina. This was one of the first very interesting cases where I found that the amount awarded was quite large sum of money that was awarded by the court. And I think that although the court in its judgment had not expressed a clear position in this regard, the adoption of an alternative solution regarding the method of payment for the total sum was different from what was done in the Ethiopia-Eritrea Claims Commission. However, there was what I found interesting is that the court looked into having a time, giving the party to pay the compensation a timeline within which to pay, and well, good enough that the parties have started the process of the payment to make a bit of a compensation. However, the challenge is also that they also looked into the issues of the economic capacity of the country to pay the compensation, because this is always a very big challenge for many states, because some are least developing, others are middle developing countries. So paying compensation takes a lot of time, takes a number of years to follow up on. And maybe also one other thing I would like to mention, this is from the African regional system in the Human and People's the court. The African court has looked at this issue of compensation from the angle of human rights. And one of the things that I found very interesting in some of the case law from the court is that compensation, even if there's a change in the political government, the government that takes on still has to follow up with the compensation mechanism. It does not exonerate them. They still have to carry out the compensation, even if it happened in the previous government. So it's one of the things that should also be looked into, because this is a different practice, a state practice, to find out whether this has, if the states, even if there's a change of government, there's always, if they've carried on with the compensation. And maybe also one other important thing that I would like to mention is that it's important to look into, like Christina mentioned about the investor-state, because the investor-state dispute, ICDS, has some jurisprudence which would provide a guide on how best this subject can be approached, because it would be interesting to see what states would have to say, especially in the State Committee, if this gained a broader discussion, because from the African perspective, it's a very, very interesting topic, but very delicate, because issues of compensation are very, very, require a lot of financial, legal, and political connotations. And I think that it would be very interesting to look into this discussion and going forward how the ILC is looking at approaching this in a long-term program of work. And that's all I had to say for now. Look forward to any questions. Thank you.
Thank you, Marvin. And I think that there seems to be sort of the recurring theme of the interaction between generals and secondary rules and the way how one implements them in a particular institutional setting and in particular fields, which is, of course, not something peculiar to compensation, but something in law state responsibility more generally. I now move to Alice and ask her to introduce the European perspective.
Thank you very much. First of all, let me thank the mission of Latvia for taking the lead in organizing this event, and of course you, Martins, for the invitation to join the panel. It is also a pleasure to speak alongside my colleagues from Uganda, Mexico, and the Philippines. Complementary to the previous speakers, my intervention will indeed focus on the European perspective on compensation under the law of state responsibility. I want to start by highlighting two important interstate cases, and I will make then some brief remarks on the relevance of compensation in the European region. And I would start by a case that you might be familiar with, which is the Arctic Sunrise arbitration of the Netherlands versus Russia. This case started when, after Greenpeace International used the vessel Arctic Sunrise, flying the flag of the Netherlands, to stage a protest against oil exploration in the Arctic near an offshore oil platform located within the EEZ of the Russian Federation. And in response to this protest, the vessel was boarded and detained, and the persons on board were also arrested, charged with criminal offenses, and held in custody for approximately 2 months. The Netherlands claimed that these actions breached several provisions, including some under UNCLOS, ICCPR, and customary international law. Indeed, the arbitral tribunal found unanimously that seizing the vessel, as well as arresting, detaining, and initiating judicial proceedings against the crew, by doing that, the Russian Federation has breached multiple obligations under UNCLOS, mostly related to the freedom of navigation. And also unanimously, the tribunal decided to award to the Netherlands compensation in total value of $5.4 million, including for compensation for damage to the vessel, compensation for non-material damage to the crew, and compensation for damage resulting from the measures taken against the crew and related additional costs for the arbitration itself. The case reflects the possibility of compensation for both material and non-material damage. And what I found interesting was the method that the tribunal used to look at this, which is that it really analyzed the jurisprudence of the ICJ, of ITLOS, and of the European Court of Human Rights, and concluded that there was no identifiable consistent practice among international courts in respect of the calculation of the award of non-material damages for wrongful detention, and certainly not one that could be automatically applied to any given case. However, it did identify consistent characteristics in those cases, namely that courts tended to award lump sums, having considered all of the circumstances of the case, as opposed to a per diem calculation for the detention. A second case that I found very relevant to our discussion was the European Court of Human Rights Grand Chamber judgment in the Cyprus versus Turkey case. This is part of a relatively small number of interstate cases, around 30, brought before the European Court of Human Rights, and one of 3 in which the court has awarded compensation. Before the judgment on compensation, there was, the judgment on merits delivered in 2001, when the court found numerous violations of the convention by Turkey arising out of the military operations it had conducted in northern Cyprus and the continuing division of the territory of Cyprus. At that time, the court thought it was not ripe for it to consider the issue of compensation in interstate cases and postponed that decision. However, 9 years later, the government of Cyprus submitted to the court their claims for what is called in the ECHR just satisfaction. I know, a bit confusing given the articles on state responsibility, but it is in essence compensation. And the court awarded the Cypriot government a total amount of 90 million euros for all those violations that it found. In doing so, the court had to consider three important elements. First of all, the timing issue, both because of the time that had lapsed since the events, but also because of the time that has passed from the judgment on the merits until the request for compensation. It also had to consider for the first time the application of that particular provision on compensation in interstate cases. And importantly, it had to decide who is entitled to compensation. According to the very nature of the convention, it was the individual and not the state who was directly or indirectly harmed or primarily injured by a violation of the convention rights. So even the court held that even if satisfaction, or in this case, compensation was afforded in an interstate case, it always had to be done for the benefits of individual victims, and that the state had to make sure that it implemented a mechanism for those sums to reach the actual victims. Beyond the case law that I just presented, it is important to note that the ECHR regularly awards compensation to aggrieved individual victims of human rights violations. So compensation in contemporary practice goes past the classical doctrine of state responsibility. I also wanted to give a nod to, of course, something that is very important in our region and the recent evolution, the establishment of the Register of Damage, which was also mentioned by two previous speakers, so I won't get too much into details. I think in terms of the relevance of compensation in the European region, and this might be cross-regional, what I'm about to start with, is that compensation serves as the most common form of reparation for damages caused arising from an internationally wrongful act. And of course, its function is purely compensatory, but relevant practice, including the Arctic Sunrise case, has shown that compensation is not limited to material damage. It extends to non-material damage as well. What seems to be lacking is consistent practice among international courts in respect of the calculation of the award for non-material damages, as judicial institutions continue to enjoy a large margin of appreciation in this regard. In terms of the monetary value, when awarded, be it in interstate cases or in investor-state disputes, the amount of the compensation can be significant. And I will end my intervention by mentioning that in the interstate ECHR cases, I think claims of compensation can be framed in a broader context, since they tend to arise from situations of crisis or conflict, such as Turkey's military operations in northern Cyprus or the armed conflict in Georgia in 2008. The particularity of this human rights-centered approach is that even if the ECHR awarded compensation in interstate cases, the sums are always destined for the individual victims of the violations. I look forward to hearing all perspectives or regional perspectives on compensation, and I thank you.
I thank you, Alice. And now I'm passing the floor to Azela. Please, you have the floor.
Thank you. Thank you, Professor. I'll try to be brief, noting the time. This is not so much an Asian perspective, but rather really it's quite domestic. I'm pleased to join this panel and I'd like to thank Professor and, of course, co-sponsors Latvia, Mexico, and Romania. I'd like to focus on locating the individual in the greater scheme of state responsibility, looking at the consequences of international responsibility from the standpoint of individuals working within systems of responsibility in municipal legal systems and beyond, when appropriate, for reparations and compensation. On Women's Day this year, the Committee on the Elimination of Discrimination Against Women issued a decision in favor of women victims of sexual slavery by the Japanese military during the Second World War. The CEDAW called specifically for Philippine authorities to provide full reparation and an official apology to the survivors, who have suffered decades of physical, psychological, and other consequences. As a context, this complaint was actually filed by 24 members of a nonprofit organization called Malaya Lolas, which means free grandmothers in our language. It's established to support sexual slavery survivors, commonly known as comfort women. As noted in their complaint, they repeatedly requested the government to support their claims for reparations, asserting that failure to fight for their cause had essentially resulted in discrimination. It should be noted that prior to the proceedings in the Philippines, a petition was actually filed by these women before the Japanese courts for compensation. And the petition was dismissed by the Japanese court, ruling that comfort women did not have personality under international law. And as such, since the claims were not supported by such, the claims had to be supported by the Philippine government. And therefore, the Malaya Lolas filed a case before the Philippine Supreme Court on behalf of 70 Filipino comfort women at that time to compel the Philippine government to support their claims for compensation from Japan. Among the core legal issues presented to the local court was the general waiver of the claims made by the Philippine government in the Treaty of Peace with Japan void, and was the Philippine government's acceptance of the apologies made by Japan contrary to international law. And did the executive department commit grave abuse of discretion in not espousing the petitioner claims for official apology and other forms of reparations? In any case, the Supreme Court of the Philippines decided, textbook international law style, stating that the executive had exclusive power to espouse the petitioner's claim, and that the executive was properly within its discretion in waiving all claims of its nationals against the Japanese government in the 1951 Treaty of Peace Act. Because of this, the Malaya Lolas filed another petition, but again, it was dismissed by the Supreme Court in 2014. 5 years later, they petitioned the CEDAW, and thus the decision by the CEDAW. Among other things, the CEDAW said that the Philippines is called upon to ensure that the Lolas should receive full reparations, including recognition and redress, an official apology, and material and moral damages for the continuous discrimination that they suffered, and restitution, rehabilitation, and satisfaction, including the restoration of their dignity and reputation, which includes financial reparation proportionate to the physical, psychological, and material damage suffered by them and the gravity of the violations of their rights. So it's a holistic compensation package based on the recommendations of the CEDAW. I don't want to go into further detail on that, noting the time, but I also wanted to make a nod on the case of certain Iranian assets. Very, very briefly, just to note that also in the same month that the CEDAW decision was released, the ICJ also issued a decision. In that case, it was honored by both sides. I mean, in the sense that the Iranian Foreign Ministry said that it believes that the ruling issued by the ICJ shows the solidity of Iran's arguments and the righteousness of Iran's request. And the fact that the court's ruling requires the U.S. to make reparations for the losses is the key reason for the legitimacy of the Islamic Republic of Iran's demand. At the same time, the U.S. also said that the ICJ judgment rejected the majority of Iran's case under the Treaty of Amity, and it's a major victory for the United States and the victims of Iran's state-sponsored terrorism. And they also noted that Iran sought to use the treaty to challenge payments to U.S. victims of Iran-sponsored terrorism who obtained U.S. court judgments against Iran. So this case has, I know, a lot of implications on ISDS, but I'd probably leave that to the experts to discuss with a small amount of time left. Thank you so much.
Thank you very much, Azul, and I think thank you in particular for highlighting the important intersection between the rules on reparation and other primary obligations under international law and implementation through the domestic legal order. I think we heard a great deal, and just as it were reminding of the starting point, we were here this morning to test the hypothesis that these are topics that are important for states in various institutional settings and regions, that there is an importance for the overall ILC framing and conceptual distinctions and terminology, and also that it may be important to have greater granularity and identification of best approaches to application. And I will leave to you to form the opinion of whether we confirmed that hypothesis from the excellent panelists that we heard. We have 5 minutes remaining, so perhaps I could open not short questions, interventions, comments, what you have heard. I see my colleague, Mr. Oyarzabal. You have the floor.
Thank you very much for this wonderful initiative and panel. And perhaps I could pose two questions that probably, I don't know if there will be time to, because they are broad ones. But the first question is, of course, we heard the issue of compensation in the context of human rights claims and in the context of investment dispute claims, and then the question, of course, arises as to what extent we can draw general conclusions or general rules for such for the wide spectrum of claims that can arise in international law, including state-to-state claims. And the second point is this panel's focusing on state responsibility, but what about the responsibility of international organizations that may arise out of course, injury, personal or material injury, and including, for instance, peacekeeping operations, but also contractual claims that may arise. Is it possible to encompass those claims in the work that you envisage? Thank you very much.
Thank you very much. I wonder whether perhaps if there are other questions or comments, we could collect a couple. I think 3 seems to be the customary number for interventions in United Nations.
Okay. Hi. Determine responsibility, talking about climate change, and for example, the advisory opinion that now is being analyzed by the ICJ. How do you determine who's responsible or who will be responding from these damages when there's not such a causal nexus, or it's blurred the responsibility, or it's collective from a lot of states? So how you determine this, like whose responsibility from this compensation? And another question would be how does compensation works in some countries where some states are unable of responding to this compensation because maybe by responding to these damages they will jeopardize other areas of their states, like for example other human rights issues like housing or food or other type of responsibility that the states have to respond to their citizens. So how you manage this compensation to other areas that are also key for the states? Thank you.
Thank you, Sergio. Do we have the final third question from a region other than Latin America? Right. Well, I think we have. Would any of the panelists like to have a half a minute crack on any of those?
I can start, but I don't want to monopolize the Latin American perspective. I can go ahead and start, and not just one response, but a general reflection on the question that had been raised. On international organizations, you're right, Ambassador. It's not just a conversation on the state-of-state responsibility. I think that shows the importance of discussing the matter further. And this year, actually, we're discussing within the 6th Committee the other draft articles on responsibility of international organizations. And I have to say also, I think in the past few years, after the pandemic especially, there's been a new, I will say, rise in interest in going back to some of these drafts, and not only these two, but of course, I think, I do 2 commercials here, sorry, but on the draft articles on crimes against humanity, I think the conversation started within the 6th Committee on how we move forward in general. And then we're having this year also some proposals to see what's next, and not just to have these discussions in the freezer, as we sometimes say, referring when we have a topic that's just in the cycle. And my other commercial here is that also I will raise the issue of private entities. And on the Inter-American system, Mexico has also brought a request for an advisory opinion on the responsibility of private arms because of the arms trafficking phenomenon that we have in our continent, but mainly that affects Mexico directly. So we're also looking forward to see what the court has to say in terms of these private entities, in particular the arms trafficking context. And on the responsibility of EOS, and perhaps one of my other colleagues may want to participate. Thank you very much.
Thank you very much, Natalia. And the wonderful expert for the Latvian mission, Elvira, has confirmed that we may go on for 3-4 more minutes, but no more. So I think that there are, sometimes there are rules. Christina.
Those are all very good questions, which I will not attempt to address in full entirely. But I think you're right about the wide spectrum of claims. I've been wrestling with that as well. I think that, it may be a function of the interaction between primary and secondary rules, where, you've set out more general framework in the, primary norms, and then drill down to more specifics in other legal frameworks. I think that's one idea. The question of responsibility of international organizations was already covered. On the responsibility for climate change, that's a huge issue, right? The issue of causation, and it's one that I think we're all going to have to grapple with. It will likely be a combination, right, of scientific evidence. It will be regional, geographical. Quantum is another big issue. How are you going to quantify damages for carbon emissions? But I think the expertise exists. It's just a matter of exercising it. And the impact of large awards, that has always been a problem, I would say, in ISDS. For example, I use UNCTAD's investment dispute settlement tool, and there, according to those figures, about 27% of investment claims were upwards of $500 million. That same site shows that investment claims over $1 billion account for 14% of cases. And these do have substantial impacts on the development of states. The Tathian case against Pakistan is one very good example, where $4.1 billion was awarded to the investor. And, that was nearly as much as a $6 billion bailout given by the IMF. And what happened in that case is Pakistan eventually had to let the project go ahead because they simply could not afford that award. So I think it is a problem, and hopefully as states mount more robust defenses on damages, we'll see these large awards not manifest as much.
Thank you, Christina. I think that now we will have to wind down. Again, I think the takeaway, I think that the breakfast panel was intended to spur our thinking of the hard questions and institutional settings. And at least for me, if I might dip my hat in one direction, it did seem that there was a cross-cutting regional interest, even if unsurprisingly, dynamics that play out a little bit differently in different institutional settings. But that is unsurprising. That is how international law works. Universal challenges are addressed with slightly different emphasis, but they have universal answers. Probably the only substantive point that I would add to the discussion in relation to climate change, that this discussion is focused on responsibility, compensation under responsibility regime, so it would not directly tell us anything about liability for lawful conduct. And I think the distinction between these two categories is probably also something that many states are thinking about, so that could be an additional layer of granularity. Please join me in thanking the wonderful panel. And have a wonderful day ahead. Thank you.